So what is the living will and how does that differ from an advance directive? In Maryland, it may be different in other states, but in Maryland, the living will consists of 3 conditions or scenarios. And under those conditions or scenarios, you can select the type of care or medical interventions you would want in those scenarios. So let's look at the first one. Let me state what the 3 are first, and then we'll look at the first one. Terminal condition, persistent vegetative state, and end-stage condition. So a terminal condition would be something that is incurable. There's no recovery, even with life-sustaining treatment, and death is imminent. Imminent is not defined in the statute, but the hospice definition of imminent is sometimes used by hospitals and doctors, and I think that would be the recommended way to go. But generally speaking, if somebody's diagnosed with stage 4 cancer and they have 6 months to live, according to the doctor, that would be considered imminent, even if it doesn't necessarily fit the hospice definition. That would probably be considered imminent. And then it's up to the person to decide how much medical intervention they want, or at that point, whether they want feeding and nutrition by artificial means. Persistent vegetative state is when there's no evidence of awareness. There may be only a flexive reflex activity. The doctors need to wait for a medically appropriate period of time for a diagnosis. This language is taken expressly from the Healthcare Decisions Act, so that's where I'm getting this information from. And that's not defined in the statute. That would be based on the practice in the area, wherever you're practicing. And then one of 2 of the persistent vegetative state certifying physicians would need to be a neurologist, a neurosurgeon, or another expert in cognitive function. And then the third condition is the end-stage condition. This is a progressive condition. It's irreversible. There's no effective treatment for the underlying condition. There's complete physical dependency, and death is not necessarily imminent. However, it will be the end result of the condition. The ones traditionally used for an example of end-stage condition is Alzheimer's, but I would add something like COPD, which I watched my father go through, and his lung capacity at the end was 30%. He weighed the weight of a small child, and he could not get out of bed. I would consider that an end-stage condition. There may be others, but those 2 come to mind immediately. So what are the options for each condition? The living will, the form that's used by the Attorney General's office, has 3 options available for the client to initial. Option 1 is keep me comfortable and allow natural death to occur. The patient does not want any medical interventions used to try to extend their life, and they do not want to receive nutrition and fluids by tube or other medical means. Now, I point you to the word nutrition and fluids by tube or other medical means, because in Maryland, that word nutrition and fluids could be used to include saline IV. Now, saline IVs could be used simply for comfort care for somebody who's dehydrated. It hydrates them back and makes them more comfortable. But I've also been told by a doctor that that's considered an invasive medical intervention. So depending on the facility you're in and the doctor you're with, they may or may not consider IV fluids as part of ordinary care or as part of extraordinary care or unnecessary medical intervention. So that's one that I point out to clients. If they still want a routine saline IV for just hydration, for comfort, then they need to talk to their healthcare agent, or somehow in the form there's a place where you can limit your healthcare agent's actions. You can limit their powers, and that would be one you might want to limit. And I use that one as an example because when my dad was in his end-stage condition and he was at a hospital in another state, and I won't name that state right now, because it was very frustrating. My father did have a written advance directive naming my brother, who at that time lived an hour away and was not on real good speaking terms. So my father was trying to appoint me as a healthcare agent, and we needed to get a doctor in the room and get a nurse to witness this. I could never get to the hospital when the doctor was available because every time I showed up, the doctor was not available. And I couldn't get anybody to help him sign a form because there was never more than one nurse available that could do it, and we needed another witness. So unfortunately, in my dad's last days, he was not able to appoint a healthcare agent. And I stress this because I think at some point that particular hospital was of the opinion that they were the ones making the decisions and not the patient and the family. But it was unfortunate because my dad, he did have a DNR in place. He wasn't seeking extraordinary medical intervention. He just wanted to make sure he was understanding all the treatment being taken care of. And the one thing that really bothered me was he was unable to eat and swallow for 3 days. He couldn't swallow, couldn't eat, couldn't drink anything, couldn't even take his medication because he couldn't swallow. It was painful. And I said, can you please get him an IV? He's very uncomfortable. He's getting agitated from the dehydration and uncomfortable. And the nurse said, is there a doctor's order for that? And that really made me think, if you need a doctor's order for an IV for somebody in that condition, then people just need to know about it. It doesn't mean, should he have gotten one or should he? I'm not going to argue with the doctor on that point, but I don't think he knew that that meant if I want to have an IV, all of a sudden I can't have one, I can't change my mind, what? The patients, as long as they have capacity, can change their mind. They can change their mind up to the point of incapacity or death. So that's important. And I'm raising that now because I think sometimes in the community, particularly the elder patients, are afraid to execute a medical directive or an advance directive because they're concerned that they are giving up all power to whoever their healthcare agent is. That's not true. A principal is always the principal, which is the person executing the document. As long as they have capacity, they can revoke it at any time, as I stated earlier. The healthcare agent can only do what the principal wants. And it's when the principal can no longer speak for themselves that the agent can then move forward based on what's written in the document. And that's why the living will can be really important in those circumstances. So option 2, let's look at option 2 now. Option 2 is the same as option 1 with respect to the first element, keep me comfortable and allow natural death to occur. I do not want any medical interventions used to try to extend my life. Those two are the same. Where option 2 differs, however, is if the patient is unable to take enough nourishment by mouth, they want to receive nutrition and fluids by tube or other medical means. Again, that doesn't mean always in every instance you have to provide this. It just means that's what their preference is, and if the medical circumstances warrant, they should be offered nutrition by artificial means. And then option 3 is the third option, which says try to extend the patient's life as long as possible using all available interventions in a response that it is a reasonable medical judgment would prevent or delay the person's death. And if they are unable to take enough nourishment by mouth, they want to receive nourishment and nutrition by artificial means. So those are the 3 options. Generally speaking, most people pick option 2 because that seems to be the most reasonable. There are some people that they're very sure option 1 is the way to go and they're adamant and they go all the way down the list, and that's fine. And then option 3, I've only had 1 or 2 people ever select option 3. And generally speaking, option 3 might be appropriate in some instances, and so I would never dissuade anybody from using option 3, particularly if you're a parent and you have children to take care of and you may need to be around for those children. That would be an example. And it just may be somebody's values. That's what their values are, and they should not be discouraged in picking any of the options. Although I would caution them on option 1 because option 1 could be pretty severe results depending on the circumstances. The goal of the Advance Directive and the living will. This is important to understand. The goal of the Advance Directive and the living will is to determine and apply the patient's wishes regarding future medical treatment to the fullest extent possible, so long as the treatment is not medically ineffective as certified by a physician. So a physician is not required to render medically ineffective treatment. They're protected by that. They're not required to do that. However, as much as practicable, the patient's wishes should be followed. So if you have a living will, which again are the 3 conditions, persistent vegetative state, end-stage condition, and terminal condition, and the patient has selected one of the 3 options that were shown on the slide, what does that affect on the healthcare agent's decision-making? Well, the healthcare agent can be bound to follow the patient's wishes exactly as stated. There is a provision in the Attorney General's form that you can select, that the patient can select, that says, I want my healthcare agent to apply my preferences exactly as stated. On the other hand, there's also a little checkpoint where you can initial, and the client or the patient can instead say, on the other hand, I want to grant my healthcare agent the maximum flexibility. That works in a lot of circumstances, because in my own life, what I've experienced is, one, you don't know what's going to happen, and two, healthcare procedures and medicine changes so quickly and so much from year to year and month to month and decade to decade. So it's very difficult to, I think, make a blanket statement. And if you're in medicine, you kind of know that. And if you've ever experienced medical miracles in your life, you also know that. Sometimes terminal means terminal, sometimes it doesn't mean terminal. Sometimes persistent vegetative state is persistent vegetative state, sometimes it's not. So, just based on my own experiences, I think you really need to just look at the broader picture and say, okay, if I can't figure out all these scenarios, what am I most comfortable with? That's what the client should be looking at. A living will is the best evidence of the patient's wishes. Again, there are lines in the form, and you could actually craft it and make it a little more specific than the checklist that is provided on the form itself. And if no living will exists, then the patient should, at a minimum, discuss his or her wishes with the healthcare agent regarding the medical treatment that they would like to have. This was a situation, if some of you are familiar with the Terry Schiavo case in Florida. One of the issues in that case, which is really disturbing to me as a lawyer, is nobody was aware of what her wishes were, other than the husband, who was soon to be her ex-husband, who was also implicated in a potential criminal aspect of her condition. Let's put it that way. So it was just a weird situation from a legal standpoint. I don't know if I was a judge in that case, I would have gone with that, because she didn't really express her wishes to anybody else, and nowhere was it in writing. But they did base it on what he thought she said. But there was no advance directive in that case, and the husband was able to make all the medical decisions in that case. Had she had one, I think the case may have turned out differently. So based on the the healthcare agent's authority, again, is based on the patient's wishes if clearly known. We look to the living will for that, and we look to the advance directive if there's any provisions. Sometimes people in the advance directive will say, I want my healthcare agent to consult with these persons. And it could be siblings, it could be best friends, it could be doctors that you have great trust in, it could be pastors, rabbis, friends of that nature, or religious friends, or just best friends who would know your wishes. That's very helpful to your healthcare agent, especially if your client is choosing somebody who is not in the immediate vicinity. But so maybe my niece is my healthcare agent. They live in New York because I'm close to her, but I play cards every Wednesday with a group of ladies, and with some of those ladies I belong to a knitting club, and I do this. So those friends in that circle might know your wishes better than your niece who lives 200 miles away. But so that's good to know. If you can include people like that, if your clients can include people like that in the advance directive, that's also helpful. If the patient's wishes are unclear, then the best interest of the patient should prevail. That's just a standard. You just look at all the factors and try and come up with what's in the best interest of that particular patient. But generally, the living will will If you don't have an advance directive, and this goes to one of the questions asked before, what happens? Well, the law provides surrogates, legally recognized surrogates, as substitute decision makers upon a patient's incapacity if there's no advance directive. And this is in the following order. A guardian, who is appointed by the court, and that's generally for somebody who has a more long-term incapacity. A spouse or domestic partner would be next. Adult children can make decisions for their parents. Parents can make decisions for their children. And then adult siblings, if none of those others are present, adult siblings can make decisions for each other. Or other relatives and friends. That's the last on the list. And it would be in that order of preference. Now, as parents, I used my son's situation before. As parents, we had the right to make that decision. But if we were in a state where they didn't know us, we'd have to show the ID. Yes, we're the parents, this and that. Now, we were local, so the doctors knew us. But it could be a situation if you're in an area where you don't know. Another problem where it comes into play, bringing in my little legal mind here, is if you have a spouse or domestic partner, what if that person's going through a divorce and doesn't necessarily have that person's best interests, but yet they're still legally the spouse and you don't know that? So there are certain sticky situations that could come up where not having the advance directive in place could provide a little bit of a conflict between the patient's interests and the surrogate's interests.